Welcome to Crime in Court. My name is Heather, and this is another episode in my deep dive series, The Tragic Death of Sandra Birchmore. And we're going to be talking again today about the civil suit, the Birchmore family seeking justice. So, this is part two of us reading through the criminal complaint from Darlene Smith, who is the aunt and representative of Sandra Birchmore in this case. And the defendants in this case are Matthew Farwell, William Farwell, Robert Devine. Josh Heel was added to this, the town of Stoughton, the Stoughton Police Department, and Darlene is this particular document is coming from Citation Insurance, so they're claiming to be the plaintiff here because this is their filing. Um, Darlene, though, is the plaintiff in this civil suit against these other individuals. All right, so just to clear that up in case that was confusing. All right, so we're going to read through this. This is a complaint for declaratory judgment with jury trial demand. So basically, Darlene Smith wants a wants a jury trial regarding the misconduct and maltreatment that Sandra Birchmore had to endure while she was going through the Explorers program and while she had these men in her life because of what they did, all of the grooming and the essay that occurred when she was younger and continued on until she died. So she was still seeing the men and having relations with them up until her end. So I'm going to skip through all of this and just get to the facts. That basically is just naming all the people in the case. All right, so facts common to all counts. So this is from the insurance company regurgitating some of the facts that have been put forth in this in uh, court documents that had been filed previously. So we are going through this court document, which is 358 pages long. We are obviously not going to read all of it, but it is basically it's put together chronologically all the different filings and things that occurred during this case leading up until where we are today. So I'll take you through where we are today, but I'm not going to read all of it, obviously. So this was filed May 11th, 2023. And at that point in time, Josh Heel was brought onto the lawsuit, but I think that he has since been dropped. So I'm not entirely sure, but this particular um, insurance company does not think Josh Heel should be on the civil suit, and we'll get to that. All right, so facts common to all counts. On February 4th, 2021, Sandra Birchmore was found deceased in her apartment. We know that she stopped communicating on her phone on the 1st. So she may have been deceased in her apartment for 3 days. She hadn't been seen from anyone since the 1st. And she did not go to work those couple of days, which bothers me. Like, why didn't her coworkers do something sooner or call sooner? Like, after one day of a no-show, aren't you trying to get a hold of that person? If not to fire them, if anything else, or to check on them to make sure that they're okay? I don't know. But anyways, bothers me that they waited until the 4th to do a wellness check. All right, so at the time of her demise, Ms. Birchmore was 23 years old. She was pregnant at the time. The father of Ms. Birchmore's unborn child was Matthew Farwell, according to Ms. Birchmore and everything that she told people. And Matthew Farwell denied it. William Farwell denied it. However, they were both having relations with her. So if either one of them were the baby's father, it would be difficult to tell because their DNA would be so identical because they're identical twins. It would be hard for them to determine um, who the father was. But Luckily, that's not a problem for them because one, the medical examiner in the Norfolk District Attorney's Office, FYI, the Norfolk District Attorney's Office has this case. It was turned over to them because Canton is in Norfolk County. And so we've got DA Michael Morrissey on this case as well. So he's the one that is not prosecuting for crimes that are clearly committed against this poor girl. Um, and the medical examiner in Norfolk County, who I don't know if it's the same one who did John O'Keefe's autopsy, but whoever did the autopsy of Sandra Birchmore failed to take a DNA test of the baby, which I don't know on what planet you do your policing and your autopsying, but I mean, everything would tell me in my common sense and common decency, get a DNA sample of that baby. The father of that baby might be a suspect because women who are pregnant don't usually take their own lives. So, anyways, that's a little complaint I have there. All right, so Matthew Farwell, William Farwell, and Robert Devine were at all times relevant to this complaint, police officers in the town of Stoughton. So this insurance company is admitting it is these three that are really the assailants here. Joshua Heel was at all times relevant to this complaint, the animal control officer in the town of Stoughton. So that was his role while these things were happening with Sandra. All right, so on or about December 29th, 2022, Darlene Smith, as the personal representative of the estate of Sandra Birchmore, filed a wrongful, I don't know if I can say that word, a wrongful D lawsuit against Matthew Farwell, William Farwell, Robert Devine, the town of Stoughton, and the Stoughton Police Department, alleging that that each of these defendants individually or in concert caused the wrongful loss of life of Ms. Birchmore. This lawsuit is herein referred to as the wrongful D lawsuit. A copy of the most recent pleadings in the wrongful D lawsuit is attached as Exhibit 1 to this declaratory judgment lawsuit. The wrongful D lawsuit also alleged that the defendants individually or in concert caused damage to Ms. Birchmore during her life by their negligence, assault, battery, improper hiring and supervision, and deprivation of Ms. Birchmore's civil rights. The wrongful D lawsuit was amended to add Joshua Heel on as an additional defendant. The wrongful D lawsuit alleges, among other things, that Matthew Farwell met Ms. Birchmore when she was 13 years old, when she was a 13-year-old participant in the Stoughton Police Department Explorers Program. The wrongful D lawsuit alleges, among other things, that Matthew Farwell began a physical, intimate relationship with Ms. Birchmore when she was 15. Again, the age of consent in Massachusetts is 16, which in my opinion is still too young, but that is what it is. So he broke the law with a minor. And in my opinion, the grooming was probably going on since she was much younger than 15. Because, yeah. All right. So the wrongful D lawsuit alleges, among other things, that Matthew Farwell intentionally groomed Ms. Birchmore for this physical relationship. Again, probably going back to when she started the program. The wrongful D lawsuit alleges, among other things, that Matthew Farwell continued his physical relationship with Ms. Birchmore continuously from the time that she was 15 years old until the time of her demise. The wrongful D lawsuit alleges, among other things, that William Farwell and Robert Devine had similar physical relationships with Ms. Birchmore. The wrongful D lawsuit alleges, among other things, that Matthew Farwell caused the demise of Ms. Birchmore. The wrongful D lawsuit alleges, among other things, that Matthew Farwell, William Farwell, Robert Devine, and the town of Stoughton committed an ongoing pattern of abuse of Ms. Birchmore that lasted nearly a decade. nearly a decade. So if she was 15 to the time she was 23, but probably more likely since she started the program at 13, the grooming began then. So since she was 13 to 23, that's 10 years of horrific mistreatment by these men. The wrongful D lawsuit alleges, among other things, the following causes of action against Matthew Farwell. So this is just Matthew: a wrongful D count, wrongful homicide, negligence, A and B count, negligent infliction and emotional distress, federal civil rights violations, and a civil conspiracy. I want to know more about the E and F. I want to know more about the federal rights violations and the civil conspiracy counts. I want to know what those entail. That would be interesting to read. Anyways, all right. So, um, citation. The citation issued a policy of the homeowner's insurance to Michelle Farwell and Matthew Farwell covering the premises of their home. This policy was assigned a number and is after referred to as the citation policy. So the policy is Matt Farwell's. This citation, this is citation insurance is the one compiling this document. So they are speaking more so for, the Matthew Farwell in this case. All right, so the citation policy was first issued to cover the period from May 31st through May 31st, 2016 through the 2017. The citation policy was renewed annually through May 21st, 2021. Citation realleges and incorporates by reference the allegations in the previous paragraphs of this complaint. The citation policy provides bodily injury coverage for bodily injury caused by an occurrence to which the coverage applies. An occurrence is defined in the policy as an accident which results during the policy period in bodily injury. Some or all of the allegations contained in the wrongful D lawsuit do not involve an accident as defined in the citation policy. There is no bodily injury coverage for injuries which are not caused by occurrence as defined in the policy. So, a bunch of legalese, basically crossing their T's and dotting their I's. An actual controversy exists between Citation and on the one hand and Matthew Farwell on the other hand as to whether Citation has any obligations to indemnify Matthew Farwell for or against any claims asserted in the wrongful D lawsuit. So they there's a kind of a conflict of interest for them to even determine that. All right, so count two, no bodily injury. Citation realleges and incorporates all the paragraphs above. Citation policy provides bodily injury coverage for bodily injury caused by an occurrence to which the coverage applies. Bodily injury is defined in the citation policy as bodily harm, sickness, or disease, including required care, loss of services, and loss of life that results. Some of the allegations contained in the wrongful D lawsuit do not involve bodily injury as defined by the citation policy. There is no bodily injury coverage for injuries which are not bodily injury as defined in the policy. An actual controversy exists between Citation and Matthew Farwell. I'm not going to read that all over again because it gets very repetitive. All right, so count three, expected or intended injury exclusion. So citation realleges everything above. Citation policy says the bodily injury. Policy excludes coverage for bodily injury, which is expected or intended by the insured. So if there is some bodily harm that comes to someone because the insured, the person doing the bodily harm, Matt Farwell, knows that it would happen or intentionally does it, then Citation isn't responsible for covering him, basically, is what they're saying. So his insurance coverage is null and void for this. Some or all of the allegations contained in the assault and battery lawsuit concern bodily injury, which were expected or intended by Matthew Farwell. So the insurance company has determined that some of these things were intended, and therefore liability coverage for the bodily injuries sustained by Ms. Birchmore is excluded by the expected or intended exclusion. An actual controversy an actual controversy exists between Citation and Matthew Farwell. The other ones it was saying, oh, it does say an actual, sorry. I thought it was saying an intent or like a, never mind. It says an actual controversy exists between Citation and Matthew Farwell. So, count three, expected or intended injury exclusion. Citation realleges everything above. The citation policy excludes coverage for bodily injury which is expected or intended by the insured. Some or all of the allegations contained in the assault and battery were expected or intended by Matthew Farwell. I just read all that. Sorry. Okay. Count four. No personal injury coverage. Citation realleges all of the above. Citation policy provides liability coverage for personal injury as defined in the Advantage Elite Extended Endorsement Form. And here's the form. I'm going to skip through it because it doesn't mean anything to me. It's all gobbledygook. All right, so personal injury is defined in the Advantage Elite endorsement as excluding false arrest, detention, or imprisonment, as well as invasion of privacy and wrongful entry. So if he entered her home without her consent, or if he imprisoned her without her, against her will, or if he, um, an invasion of privacy, he was tracking her. We know he was tracking her. She knew he was tracking her. So that is also another invasion of privacy, I'm sure that might be excluded from this policy. The Advantage Elite endorsement excludes personal injury coverage for any injury caused by a violation of a penal law or ordinance committed by or with the knowledge of consent of any injured. So again, if you're committing a crime like grooming and essaying a minor or taking the life of a woman who you might have gotten pregnant, yeah, those are crimes. All of that. So the insurance company would not insure this. Matthew Farwell knew or should have known that the assault and battery of Sandra Birchmore, as alleged in the wrongful D lawsuit, was a violation of a penal law or ordinance. He was a cop, remember, so he should know everything he was doing that was illegal, and yet he knowingly attacked Ms. Birchmore. Some or all not only attacked but preyed upon and took advantage of. Some or all of Matthew Farwell's actions surrounding Ms. Birchmore, as alleged in the wrongful D lawsuit, were performed within the course and scope of his employment with the town of Stoughton and the Stoughton Police Department. The Advantage Elite endorsement excludes personal injury coverage for any injury arising out of the business pursuits of any injured. So because Matthew was grooming Sandra and doing these things throughout the course of his work, during the day, while he was working in cop cars. I don't know if Matthew Farwell was doing that, but we know that the other two were William Farwell and Robert Devine. Were having her meet them at his car for physical time. So if it has anything to do with personal pursuits, which it does because it was under the town of Stoughton while he was the Stoughton police officer and under the program under the Stoughton Police Department. So the Advantage Elite endorsement excludes personal injury coverage for any injury arising out of business pursuits. The personal injury caused by Matthew Farwell excluded from coverage because it arises out of Matthew Farwell's business pursuits. So basically, just reiterating the same thing. An actual controversy exists between Citation and Matthew Farwell. Count 5A and SA exclusion. Citation realleges and incorporates herein all previous paragraphs as if fully set forth above. The coverage grant of the citation homeowners policy states that If a claim is made or a suit is brought against an insured for damages because of bodily injury or property damage caused by an occurrence to which the coverage applies, we will 1. Pay up to our limit of liability for the damages for which the insured is legally liable. Damages include prejudgment interest awarded against the insured. So, citation homeowners policy excludes coverage for injuries arising out of SA, corporal punishment, or physical or mental A. The wrongful D complaint alleges that the injuries to and or the loss of Ms. Birchmore's life rose out of the physical or mental A. So even if she didn't take her own life, or if she even if she did, sorry, even if she did take her own life, it was because of their actions. So they led her to that because of all of the abuse that she endured. Citation has no duty to indemnify Matthew Farwell for or against all claims in the wrongful D lawsuit, and an actual controversy exists. Count 6, claims outside of coverage period. Citation realleges all of the above. The coverage grant of the citation homeowner policy, we read that already, says an occurrence is defined in the policy as an accident which results during the policy period in bodily injury. Some of the injuries alleged by the estate of Sandra Birchmore occurred prior to the citation policy period. So some of the injuries, some of these incidents where Sandra was groomed, essayed, um, whatnot, whatever they were doing with her, she it would happen before the policy even was um, purchased. Citation has no duty to indemnify Matthew Farwell for or against any claims in the wrongful D lawsuit which occurred outside of the policy period. An actual controversy exists. Count 7, known loss defense. Citation realleges everything above. Under mass law, the insurable risk is eliminated where an insured knows when it purchases a policy that there is substantial probability that it will suffer or has already suffered a loss. So you're not supposed to uh, take out insurance after the fact. At that point, the risk ceases to be contingent and becomes a probable or a known loss. In the wrongful D lawsuit, Matthew Farwell knew that Ms. Birchmore had already suffered a loss at the time that the citation policy was first issued and upon each subsequent renewal. Some or all of the claims in the wrongful D lawsuit cannot be maintained because they were known losses or losses in progress which are uninsurable. An actual controversy exists. So basically, the things that we might have been able to insure it, we can't anyways because it's a breach of our contract, but also you weren't insured at the time of the incidents. I mean, they're really laying it out. Like, we want nothing to do with our client, Matthew Farwell, and this lawsuit. Citation realleges and incorporates by reference the allegations above. The amended complaint in the wrongful D lawsuit contains claims pled in the alternative, including but not limited to claims of negligence as an alternative to claims of intentional battery. If it is in the financial best interests of the estate of Sandra Birchmore for citation to provide insurance coverage for the allegations that they have made in the wrongful D lawsuit. It is in the financial best interests of of Matthew Farwell for citation to provide insurance coverage for these allegations because the estate of Sandra Birchmore on the one hand and Matthew Farwell on the other hand share a common interest with respect to insurance coverage, even though they are adverse as to other matters. The wrongful D lawsuit will not be fairly litigated within the meaning of Commerce Insurance Company versus Farowitz. Commerce is entitled to litigate in this declaratory judgment action all matters that were not fairly litigated in the wrongful death lawsuit. So the insurance company was entitled to litigate certain things. All right, so segregation of damages, count 9. Citation realleges everything above. Most of all of the damages sustained by Ms. Birchmore, uh, most, if not all, sorry. Let me slow down. I'm trying to, like, I read fast, I do everything fast, I got ADD, and I gotta slow down. All right, most, if not all, of the damages sustained by Ms. Birchmore were caused by the non covered acts of Matthew Farrell and not by acts which might be covered under the homeowner's policy. It is in the financial best interest of the estate of Sandra Birchmore to seek a general verdict rather than a verdict which allocates between claims which might be covered and those which are not. It is in the financial best interest of Matthew Farwell for citation to seek a general verdict rather than a verdict which allocates between claims which might be covered and which might not. Because the estate of Sandra Birchmore on the one hand and Matthew Farwell on the other hand share a common interest with respect to insurance coverage, even though they are adverse to most all other matters, the damages in the wrongful lawsuit will not be fairly allocated and thus not fairly litigated within the meaning of Commerce Insurance Company versus Schwafarowitz. Commerce is entitled to litigate in this declaratory judgment action all matters that were not fairly litigated in the assault and battery lawsuit, including the allocation of damages in the wrongful D lawsuit. Count 10. Declaratory judgment versus the estate of Sandra Birchmore, William Farwell, Robert Devine, Joshua Heel, the town of Stoughton, and the Stoughton Police Department. Citation realleges everything above. This estate of Sandra Birchmore is the plaintiff in the wrongful D lawsuit. William Farwell, Devine, everybody else is against the defendants. A citation may not be able to conclusively establish its rights and duties to its insured, Matthew Farwell, unless the estate of Sandra Birchmore, William Farwell, Robert Devine, Joshua Heel, the town of Stoughton, and the Stoughton PD are all parties to and are bound by this action. So they all have to agree as well. Citation is entitled to the declaratory judgment stating that the estate of Sandra Birchmore has no rights against citation, and that citation has no obligations to the estate of Sandra Birchmore with respect to any insurance coverage for the allegations against Matthew Farwell in the wrongful D lawsuit. So they are basically saying we want the judge to say we don't owe anything. We are out of this. It is between the estate of Sandra Birchmore and all the others. Matthew Farwell, we may be able to insure some things, but probably not all. Definitely not all. Citation is entitled to a declaratory judgment stating that Matthew Farwell, Robert Devine, Joshua Heel, the town of Stoughton, and the Stoughton PD have no rights against citation. That's basically all they want. And that citation has no obligations to all the other people on the lawsuit. So he's just trying to say William Farwell is the only one that has the insurance coverage and that citation will be working with. They want a jury trial. Citation demands a trial by jury as to all issues so triable. And this helps in this case because the estate of Sandra Birchmore, Darlene Smith, wants a trial also. Wherefore, citation requests that this court enter judgment declaring that citation has no duty to indemnify Matthew Farwell for the damages alleged by the estate of Sandra Birchmore in the wrongful D lawsuit. Enter a judgment declaring that the estate of Sandra Birchmore, William Farwell, Robert Devine, Joshua Heel, the town of Stoughton, and the Stoughton PD are all bound by the declarations issued by the court in this case and grant such other and further relief as the court deems appropriate. And that is signed by Lawrence Slotnick, who is the attorney for Citation Insurance Company. All right, so we're going to kind of fly through the rest of these. I'm not going to read all of them, but we're going to, let me actually shrink it up so we can see more of the pages here. So we're going to be zooming by. So we're looking through the exhibits and other things. So this is actually a second amended complaint and demand for jury trial. So basically, a lot of these things get reiterated, things get published, reposted. So this is the same thing we've read through. There might be some alterations, but for the most part, it's still all the counts I looked through. So let's see. We've gone through all of these accounts or all of these counts already. Here is the distress. Oh, we did read through that. The significant emotional distress that they cause, counts 9 and 10 that I wanted. The plaintiff alleges above at all times relevant here to the officers or officers, blah, blah, blah. Where does it talk about? So this is the conspiracy charge. This is what I wanted to know, what the conspiracy was. So, throughout the relevant period of time, I'm going to just start reading randomly. All right, so throughout the relevant period of time which the A took place, the officers were creating or operating under the color of law. Let me make this bigger. The A, grooming, and SA all took place and was facilitated by virtue of the officers' position as police officers and educators within the program, and further by Heel's position as an animal control officer. Throughout the duration, the officers acted under the authorization by the government within the program, abusing their authority within both the program and as police. Um, the officers SA of Ms. Birchmore as a minor all occurred while the officers operated under the color of law and in abuse of the positions given to them. So, how is this conspiracy? There exists a clear nexus between the officers' official duties as police officers and educators within the program and their inappropriate SA conduct with Ms. Birchmore dur- over the duration of the program. So I guess that the fact that they're officers and it's like a dual role as like an officer and an educator, like you used that role and that power not for good but for evil, so therefore it's a conspiracy. I don't know how that's a conspiracy, but that's what it said count 10 was. Oh wait, that was 9. Here's conspiracy, sorry. What was that for? It doesn't say count 9, it just says violations. Here's the conspiracy: civil conspiracy against Matthew Farwell, William Farwell, Devine, and Heel. During their employment by the town of Stoughton, the defendants worked in concert with each other throughout the duration of the program. And so that's it, working together with one another to coerce and manipulate the decedent into engaging in illicit activities, physical activities, oftentimes during the scope of their employment. So that's the conspiracy. Okay. I know we read through it, but I forgot. Didn't remember what the conspiracy part was. All right. Sorry about that. I just get off track sometimes. So again, we're just kind of scrolling through. We're only on page 62, by the way, of 300, but we're definitely not reading all of this. So that everyone gets to respond to the insurance company's filing that we just read. So everyone responds. So this is Darlene Smith's answer to citations insurance complaint. So as you can see, it's like defendant admits allegations contained in that paragraph. Defendant alleged has insufficient information. It's just them responding. So it's on the record and they have their responses in. So we're going to fly through that. And then the next one is defendant Matthew Farwell's answer. So boom, 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 boom. He, his answers, actually, let's just back up. He denies everything. Just he admits some things. So let's say like there he admits something, whatever was in paragraph 75. And then again, he's got insufficient or denies. He's got a lot of denies, though, I will say. Deny, deny, deny. All right, so up next is the plaintiff's motion for leave to file a second amended complaint. basically, what do they want? Therefore, in an effort to be efficient before service is made, the plaintiff requests that her second amended complaint be allowed and add to additional defendant. Oh, they wanted to add the defendant, Joshua Heel. That was that filing there. This is the answer from Josh Heel. He denies everything too, but he really did not have as big of a part, but he still did, in my opinion, take advantage of her, and he failed her as the adult, although he says that he met her when he was an adult. But still, as the more mature person of the two, when someone comes to you and tells you um, that these things were, what was I trying to say? I don't know. Um, all right, so we're gonna, sorry, I don't know. I lost my train of thought because I was trying to think about the rest of this episode. I'm always looking 10 steps ahead. All right, so this is the facts according to Joshua Heel. This is what I wanted to read through. So we'll continue we'll continue on with the document in just a bit, like going through it quickly, but I just wanted to read some of the cross claims. Again, this is coming from Josh Heel's attorney. So, at all times relevant, Mr. Heel was not and is not a target of any criminal investigations by the Stoughton PD into the homicide of Sandra Birchmore or any other claims arising out of the SPD internal affairs investigation. So, he was part of the internal affairs investigation, but nothing came of it. He didn't lose his position. They didn't say, uh, yeah, so we don't know. We don't know. He was not told to be decertified or anything like that. So he's still in good standing as an officer. So apparently the IA investigation came up with nothing for Josh. At all times relevant, Josh Heel was not and is not a target of any criminal investigations by the Mass State Police into the homicide of Sandra Birchmore. At the conclusion of the SPD-IA investigation conducted by Deputy Chief Brian Holmes, SPD turned over the IA investigation report to the Norfolk County District Attorney's Office. The attached exhibit is a true and accurate copy of the unredacted SPD-IA report. At all times relevant, Mr. Josh Heel was not and is not a target of any criminal investigation by the Norfolk District Attorney's Office. At all times relevant and continuing, the town of Stoughton, sorry, and SPD were and are aware that Mr. Josh Heel was not and is not the target of any criminal investigation into the loss of Sandra Birchmore's life or any other criminal investigations or claims arising out of the investigation. When the IA investigation was completed, Stoughton and Stoughton PD knew that Mr. Heel did not groom, engage in underage assault and battery, the R word, or any other act. I can't say any of those things, or conduct, any kind of misconduct that would be construed to be anything other than consensual activity between two consenting adults. When the IA investigation was completed, Stoughton and SPD made no recommendations regarding punishment, decertification, or any other action adverse to Mr. Heel, or that would have or should have impacted his chosen career as a police officer. At all times relevant and continuing, Mr. Heel was not charged with a crime involving any criminal act with respect to Sandra Birchmore. At all times relevant and continuing, Mr. Heel was not convicted of a crime involving any criminal act with respect to Sandra Birchmore. On December 7th, 2021, Deputy Chief Brian Holmes wrote to Chief David Del Papa of the Abington Police Department and advised, I am writing to inform you that a member of your department who is also a former employee of the department is a witness in an ongoing internal affairs investigation. So he was just a witness, apparently. Patrolman Joshua Heel will be requested to appear for an interview related to this investigation. Deputy Chief Holmes continued, "Through my prior working relationship with Officer Heel, I would anticipate his cooperation in this process, and I expect to have an interview prepared prior to the end of the year. A true and accurate copy of this correspondence is attached hereto as Exhibit 2. As the conclusions of the IA investigation and continuing, neither at the conclusions of the IA investigation and continuing, the weird sentence, neither Deputy Chief Brian Holmes nor SPD agents Paul La Italian thought, believed, or concluded that Mr. Heel had anything to do to warrant punitive measures. Mr. Heel started work as an animal control officer for Stoughton on March 6, 2016. On an ordinary day, Mr. Heel began his shift at the Stoughton PD located in Stoughton. Mr. Heel's shift started around 8 a.m., at which time roll call for police officers would be ending. His typical routine would be to proceed to dispatch and then go down to the animal shelter. The animal shelter is located also in Stoughton, 1.5 miles approximately from the PD office. Mr. Heel did not have any personal relationship with Mr. Farwell outside of work and did not socialize with him. Mr. Heel and Mr. Farwell were not friends. Mr. Heel knew William Farwell as being employed by SPD and that he was the brother of Detective Matthew Farwell. Mr. Heel was not friendly with William Farwell outside of work. He knew William Farwell in passing and described their engagements as just water cooler talk. William Farwell worked the opposite shift to Mr. Heel. Mr. Heel had no personal relationship with Officer Robert Devine outside of work. When Mr. Heel started employment at Stoughton, Officer Robert Devine was a dispatcher at SPD. Mr. Heel described their relationship as solely a professional one. The two men should have work-related discussions and had no other personal relationship outside of work. Mr. Heel and Mr. Devine were not friends. Mr. Heel would use his department issued cell phone for official department business. He would keep that cell phone for work only. When he spoke to or communicated with anyone else, he would use his regular and personal cell phone. During the IA investigation, Mr. Heel was asked about his private email account because he received a voucher that he received from the Massachusetts Animal Fund. The email was for receiving a voucher to spay or neuter animals. The receipt of the voucher resulted in no cost to the town, and it was simply a form that he submitted to aid in his work as the town's ACO. The voucher and its receipt from the Massachusetts Animal Fund is the only mention of Mr. Heel's private email account in the entirety of the IA investigation report. There is no evidence or support in the IA investigation that Mr. Heel had any explicit or intimately charged emails with Sandra Birchmore. The IA investigation revealed no evidence of email exchange between Mr. Heel and Sandra Birchmore. At all times relevant, Mr. Heel was not a uniformed police officer. Mr. Heel first met Ms. Birchmore in approximately the late summer or early fall of 2019 when she first came in to adopt a cat. This was the beginning of their friendship. During the IA interview on December 21st, 2021, Mr. Heel told Deputy Chief Holmes he first met Sandra Birchmore approximately 2 years ago. Mr. Heel did not know who Ms. Birchmore was prior to that and had no prior personal relationship with her prior to that time. So basically, he knew her as an adult, is what he's trying to get at. According to the transcript of Mr. Heel's IA interview, Mr. Heel does not know the time when he first met Sandra Birchmore. He believed it was springtime, but he did not know the month, year, or date. He did, however, know that soccer was being played on the fields adjacent to the animal shelter where he first met Sandra Birchmore. Notwithstanding that, he does not know the precise date when he met Miss Birchmore. Mr. Heel did not know Miss Birchmore when she was a minor and under the age of 18, and certainly did not when she was younger than 16. So he didn't know her when she was younger than 18, and obviously that means he didn't groom and essay her as a minor. All right. Sorry. Throughout the time he knew her, Mr. Heel considered Sandra Birchmore to be a friend. Ms. Birchmore talked with Mr. Heel often about having physical relations. He would not have physical relations with her and rejected those advances, except once. We'll get to that. Mr. Heel did have, or I'm sorry, Mr. Heel did not have intercourse with Ms. Birchmore at the animal shelter or anywhere else. During the IA interview with Deputy Chief Holmes and Paul La Italian, and according to the transcript of his interview, Mr. Heel acknowledged one occasion where he received oral from Ms. Birchmore after work. He did not know the exact date or time of this encounter other than to state it occurred approximately 2 years ago. This encounter occurred after work, off duty, and inside the animal shelter building. Mr. Heel was reluctant to disclose this incident for no other reason than he was married at the time. This encounter was a consensual act between two adults who knew each other. So it still happened on property in the animal shelter, and he still knew she was vulnerable. So that's what bothers me about that. Even though it was supposedly consensual, this encounter was consensual. All right, so neither Stoughton nor SPD have alleged that this single act of oral between two consenting adults was an incident where Mr. Heel took advantage of Ms. Birchmore. There is nothing in the IA investigation report wherein Deputy Chief Holmes nor anyone else reached the conclusion that Mr. Heel had taken advantage of Miss Birchmore at any time or for any reason. Neither Stoughton nor SPD have any evidence of Mr. Heel having taken advantage of Ms. Birchmore at any time. The personal representative of Sandra Birchmore's estate has no knowledge, information, or evidence that Mr. Heel took advantage of Ms. Birchmore at any time or that their single encounter was anything more than a consensual act. During his interview with IA, Mr. Heel was asked uh, whether the incident he recounted took place on the love seat in the office of the animal shelter. Mr. Heel stated, "I don't think that was there at the time. I don't remember." Notwithstanding the statement, SPD undertook a forensic examination of the love seat in the animal shelter. The forensic examination, at taxpayer expense, by the way, revealed nothing showing any type of DNA or other result causing implication of Mr. Heel in any conduct related to the love seat. But he testified it wasn't there, so. At various times during their friendship, Ms. Birchmore tried to introduce Mr. Heel to a couple of her friends, even though Ms. Birchmore knew Mr. Heel was married. Mr. Heel was clear to Ms. Birchmore that they were friends and nothing more. Ms. Birchmore would accept when he took oral from her. So, yeah, except for that time and other times. We'll get to that. Ms. Birchmore would come to the animal shelter from time to time if she were in the area to visit, pet, or play with the cats or dogs at the shelter. Mr. Heel and Ms. Birchmore spoke frequently via text, sometimes on a daily basis, and sometimes not often, but by phone. Based on this friendship, Mr. Heel got to know Ms. Birchmore and was then privy to what was going on in her life. Miss Birchmore would come to the animal shelter from time to time and the schedule of her visits were variable. When Miss Birchmore first started talking with Mr. Heel, Miss Birchmore would come by the animal shelter more often. Mr. Heel was aware that Miss Birchmore had been sectioned by SPD for some ongoing issues of mental health. Again, that knowing the things that happened to her by these other Stoughton cops and knowing that she had mental health issues. So, in this regard, I do think that Heel might not have been the greatest friend for her. Like, he didn't, although I don't know what you can do to help in those situations, but as an officer of the law, aren't you kind of required to report that those officers were doing things to minors? I mean, isn't that their duty? Anyways, plus, so now he knows that she had mental health issues she struggled with, and the fact that these men were doing these things that he knew about, and he's still taking advantage of her. Based on their friendship, Mr. Heel learned Ms. Birchmore had struggled with her own mental health and that she was working to address those issues. At all relevant times, Ms. Birchmore was fairly open to describing her mental health status. Mr. Heel first learned Matthew Farwell was in Ms. Birchmore's life approximately 3 months after he met her. So that's when he learned about it. All right, so when their friendship began, Ms. Birchmore shared with Mr. Heel that she was seeing someone and that they had her phone number, and could track it. So he told her he was tracking her, or could track her at least. But he really was tracking her. Ms. Birchmore shared with Mr. Heel that the person who was tracking her could see that she was at the shelter with him and that that person was texting her and asking her why she was at the shelter. So she was being tracked. She knew she was being tracked by Farwell, and so this is proof. This is proof that she knew she was being tracked and he was texting her, why are you at the shelter? Who are you talking to? Why are you with that guy? Type of things. Yeah, so that's proof that he was tracking her. Mr. Heel later learned the person tracking Ms. Birchmore's cell phone was Matthew Farwell. Ms. Birchmore shared with Mr. Heel that the tracking on her cell phone was on because she had a bad relationship in the past and had taken out a restraining order against a former boyfriend. I don't know how that makes sense. Ms. Birchmore also shared with Mr. Heel that she was having physical relations with Mr. Farwell's twin brother, William, and another officer, Robert Devine. Ms. Birchmore shared with Mr. Heel that some of these encounters would occur at Matthew Farwell's marital home, or they would meet down at the soccer field near the animal shelter. Based on what Ms. Birchmore told him, Mr. Heel formed the impression that these individuals were on duty when they met Ms. Birchmore for these encounters. Ms. Birchmore shared with Mr. Heel that on some occasions she would meet with these men in a police cruiser. She would sit in the cruiser and they would have relations while in the cruiser. Mr. Heel told Deputy Holmes during his interview on February 9th, 2022, that Ms. Birchmore told him she had relations with William Farwell on multiple occasions in a police cruiser. Deputy Chief Brian Holmes and Paul La Italian interviewed Mr. Heel on December 21st, 2021, as part of the SPD's IA investigation. Mr. Heel and Ms. Birchmore were not partners um, physically, despite the fact that they would exchange in graphic or explicit text messages. At no time had Mr. Heel and Ms. Birchmore engaged in intercourse. But as you can see, he accepted oral and he continued an explicitly adult type of conversation going on with her. All right, so during the course, during the course of their friendship, Ms. Birchmore told Mr. Heel that she had physical relations with Matthew Farwell. She knew Mr. Farwell was married. During the course of their friendship, Mr. Heel encouraged Ms. Birchmore to move on with her life and to find her own track in life, such as going to college or doing what she wanted to do. Ms. Birchmore wanted to join the Army. At all times relevant, based on what she said to him and her actions, Mr. Heel believed Ms. Birchmore was in love with Mr. Farwell, Matthew Farwell. As Ms. Birchmore's friend, Mr. Heel tried to explain to her that Mr. Farwell already had a family and that it was a lot for him to leave his family for her. Ms. Birchmore got caught up in the fact that Mr. Farwell had a family, another baby on the way, and that it was unlikely that Mr. Farwell would leave his wife to be with Ms. Birchmore. Ms. Birchmore also told Mr. Heel that she had been pregnant 3 times. This is news. This is news to me. I didn't know this. A lot of this is new. This stuff coming from Josh Heel, from his attorney's um, filing here. So apparently she had been pregnant 2 other times before, or 3 other times before, potentially. She was currently pregnant with Matthew Farwell's baby, that Matthew Farwell wanted her to have the A word and that she was very adamant about not having that A word. She wanted to keep the baby. During his interview with IA, Mr. Heel told Deputy Chief Holmes and Paul LaItalian that Ms. Birchmore's goal was to have a family where her and Matt would live together and have children together and live happily ever after. Well, we know that's not going to happen because he's never going to leave his wife, especially for the girl that he had been grooming and essaying for years. Mr. Heel had a general awareness of the physical relations that Birchmore had with other members of the SPD. Deputy Chief Holmes and Mr. La Italian asked Mr. Heel if he believed all of what Ms. Birchmore had told him. Mr. Heel responded that he did not always believe what Ms. Birchmore had told him because he knew of her lying from time to time and that he had previously caught her lying or embellishing various aspects of her life. At, as time went on and Mr. Heel changed careers, his friendship with Miss Birchmore fizzled out, and they barely spoke. For example, Mr. Heel did not know Sandra Birchmore moved from Stoughton to Canton. Miss Birchmore told Mr. Heel that she was having relations with people in the SPD. Mr. Heel acknowledged some of the text conversations got pretty intense and graphic. For example, Ms. Birchmore shared with Mr. Heel that she wanted to have a threesome. Ms. Birchmore shared graphic and explicit photographs and/or video with Mr. Heel that William Farwell had sent of his own wife. If your head's not exploding at this point, then your head's unexplodable. It won't explode. Um, so William Farwell, also married, sending pictures of his wife doing adult things. He sends that to Sandra, and Sandra sends this to Josh Heel. So, wow, poor Mrs. Farwell. If she's probably ex Farwell now. All right, so Ms. Birchmore also shared with Mr. Heel, who stated during his IA interview that Matthew Farwell sent Ms. Birchmore explicit pictures, but that Ms. Birchmore did not share those pictures with him. So Matthew Farwell sent pictures to Sandra, but she didn't share that with Heel. Ms. Birchmore did not share with Mr. Heel that she had any kind of physical encounter or relationship when she was with or in the Stoughton Police Explorers. So she didn't really talk about that. Ms. Birchmore specifically told Mr. Heel that she had physical relation with Mr. Farwell. At some point, Mr. Heel told Ms. Birchmore that Mr. Farwell and his wife were expecting their third child. So Josh Heel told Sandra that. That's how she found out. Miss Birchmore had not known of the fact and seemed a little upset about it. She did not know because Mr. Farwell had not told her that his wife was expecting their third child. Wow, this guy sucks. Miss Birchmore shared with Mr. Heel that she had planned to reach out to Mr. Farwell's wife and drafted a message that she had intended on sending to Mr. Farwell's wife. That right there, my friends, is motive. Motive for Matthew Farwell to eliminate the problem before his wife finds out. During his IA interviews, Mr. Heel stated to Paul LaItalian that Ms. Birchmore never told him when the physical relationships with Mr. Farwell started. Ms. Birchmore did not share timeframes or ages when these relations began. Mr. Heel was positive of that because if a relationship began before she was 16, Mr. Heel stated that's something that would have been a red flag in my mind. At all times relevant, that information, well, I don't totally feel like this was okay. So Josh Heel's knowledge was that as an adult, Sandra was going around and just sleeping with all these police officers and was in love with Matthew Farwell and had his baby, or he wanted to have his baby. She was pregnant with his baby. So that's in his mind, it's all consensual. It's all she wants it, like this is her conscious decision, but he doesn't have the knowledge that Matthew Farwell, William Farwell, and Robert Devine had been grooming her and essaying her from as far back as 15 years old, so or earlier. So from his perspective, he thought this was all consensual on Sandra Birchmore's part as a consenting adult. But even though she is an adult at this time, she's still a victim of all three of those men and possibly Josh. So he says it would have been a red flag in his mind. At all times relevant, the information Mr. Heel reported to Paula, Italian, and Deputy Chief Brian Holmes was based on information Ms. Birchmore had shared with him and told him. Mr. Heel did not receive information that he relayed in his statements during the internal affairs investigation that came from William or Matthew Farwell or Robert Devine. During the IA investigation, Mr. Heel told Mr. La Italian Ms. Birchmore believed Matthew Farwell was the baby's father. Mr. Heel did not know whether to believe Ms. Birchmore because she was having relations with other people. At all relevant times, Mr. Heel did not speak or communicate with Matthew Farwell about Ms. Birchmore or any of the subject matter set forth. Neither did he speak with William Farwell or Robert Devine about Sandra Birchmore. During his interviews during the IA investigation, Mr. Heel told Deputy Chief Brian Holmes that he did not always believe what Ms. Birchmore told him because she told lies all the time and he caught her in lies multiple times. He advised that Ms. Birchmore was not always truthful. Matthew Farwell did not personally communicate to Ms. Birchmore that his wife was pregnant with their third child. Mr. Heel learned of Ms. Birchmore's homicide from Officer Victoria DeNeno of SPD. Officer DeNeno knew Mr. Heel was friendly with Ms. Birchmore and wanted to let him know that she had passed away. By February 9th, 2021, so this is already, what, 4 or 5 days after? So she was found on the 4th. On February 9th, Mr. Heel no longer worked for the town of Stoughton and had taken a position as a police officer with the town of Abington. So he was transitioning jobs there. Mr. Heel was aware that Ms. Birchmore was a former explorer in the town of Stoughton in the Police Explorers program. At all times relevant, Mr. Heel was not employed by the town of Stoughton or SPD when Ms. Birchmore was involved with the Stoughton Police Explorers program. At no time did Mr. Heel have any involvement, oversight, or participation in the Stoughton Police Explorers program, nor did Mr. Heel have any involvement, oversight, or participation in the program when Ms. Birchmore was no longer a student there. So, at no time. They could have just said. All right, so Ms. Birchmore was a member of the Stoughton Police Explorers program from 2010 to 2016. Mr. Heel did not have any interaction with Ms. Birchmore when she was a member of the Stoughton Explorers program. On Friday, September 23rd, 2022, Chief of the Stoughton Police Department, Donna McNamara, held a press conference to release and discuss the results of the internal affairs investigation, and we listened to that in depth on my channel. The entire press conference was placed upon the internal affairs investigation. During the press conference, Chief McNamara identified Matthew Farwell, William Farwell, and Robert Devine as the subjects of the investigation and that she was taking action to decertify these individuals as police officers so as to prevent them from ever working as police officers again. So decertifying them, they have to be certified in order to be an officer in good standing. You can become not certified, which might be like you're in a holding period. You might be, going through some kind of administrative process like this, where they're being investigated. Or you can be decertified, which Matthew Farwell took a deal and decided he would just decertify and move on and whatever. So he's still out there potentially essaying and grooming other people, but he's just not in the police department anymore. So there's that. And we have post-commission hearings. The post-commission is the accreditory body that gives them their accreditations or not. So we have in future episodes coming up, we're going to have the post-commission hearings for both William Farwell and Robert Devine. There's none for Matthew because he's said, okay, I'll decertify and get in less trouble. So, all right. So Chief McNamara did not identify Mr. Heel by name at the press conference, however, indirectly insinuated that Mr. Heel was culpable or otherwise caused Ms. Birchmore's homicide and that he had taken advantage of her. Chief McNamara knew at the time of the press conference that the encounter between Mr. Heel and Ms. Birchmore was consensual, and the SPD had no evidence that Mr. Heel had taken advantage of Ms. Birchmore at any time. At the time of the press conference, Chief McNamara knew that the encounter between Mr. Heel and Ms. Birchmore took place when both were adults. So basically, throwing McNamara under the bus, saying she should have known better and she shouldn't have said the things that she said about my client. And yeah, here's why. So at the time of the press conference, Chief McNamara had in her possession, as did the town of Stoughton, the IA investigation report that found Matthew Farwell, William Farwell, and Robert Devine were the subject of the IA investigation. At all times relevant, Mr. Heel was not the subject of the IA investigation. At all times relevant, neither SPD nor the town nor the town of Stoughton notified Mr. Heel that he was the subject of an investigation. So he was never told he was being investigated. In the AI investigation report, Deputy Chief Brian J. Holmes recommended that Chief McNamara make a report to the Massachusetts Police Peace Officer Standards and Training. So that's the Post Commission. The Massachusetts Peace Officer Standards and Training Post Commission, and that the department sought to have Matthew Farwell, William Farwell, and Robert Devine decertified as police officers and added to the National Decertification Index, which is where um, Trooper Proctor is going also in the Karen Reed case, hopefully very soon. Our Deputy Chief Brian J. Holmes did not identify Mr. Joshua Heel as the target of the investigation, nor did he recommend that Mr. Heel be recommended for decertification to post. On March 2nd, 2022, Deputy Chief Brian J. Holmes sent a memorandum to Chief David Del Papa of the Abington Police Department described in the IA report's index of exhibits as a deposition memo. A true and accurate copy of this memorandum is attached. In his memorandum, Deputy Chief Holmes stated, while Officer Heel was employed by the town as the ACO, he made friendship with a person named Sandra Birchmore. Birchmore was known to several members of this department as having mental health issues and a lack of direction in life in general. Throw that in there, why don't you? During the course of their friendship, Birchmore disclosed to Heel many things, including her relationships with other members of this department in explicit detail. Officer Heel corroborated some facts for the investigation. So he was helpful and he didn't do anything wrong. All right. So he continued, during the interview, Officer Heel admitted to a single act of indiscretion between himself and Birchmore. This action reportedly took place while Heel was off duty. It is anticipated that this investigation will be open and ongoing for several more months. I do not anticipate seeing any additional interviews with Officer Heel. The full investigative report will be completed when the case is closed. Thank you again for your assistance. Please contact me if you have any questions. Deputy Chief Holmes made no findings or recommendation regarding any wrongdoing of Mr. Heel. Deputy Chief Holmes did not advise Chief Del Papa that Chief Heel had taken advantage of Miss Birchmore, nor that he did anything wrong. And I'm getting the signs from the doggos that they need their potty break. So I'm going to pause here. I'll be right back. Thank you guys so much for your patience. All right, sorry about that. All right, so we're almost done here with this particular document, just a couple more pages on this, and then we'll pretty much be done. But just wanted to let you know where we were in regards to timing and such. All right, so Deputy Chief Holmes described the oral incident as a single act of indiscretion, which Mr. Heel admitted to. Deputy Chief Holmes' characterization is different from Chief McNamara's description of Mr. Heel during the September 23rd, 2022 press conference. So the person who investigated it determined that it was a single act of indiscretion, whereas the chief of Stoughton may have made it seem like it was more than what it actually was, potentially. All right, so to the contrary, Deputy Chief Holmes acknowledged to Chief Del Papa that the one incident that was learned during the investigation happened when Mr. Heel was off duty. Despite not having identified, but they don't, but they failed to mention that it was still on Stoughton PD property. The animal control department was there, like it was the animal control office that it happened in. So off, even though it was off duty, it was still on the premises, right? So I don't, just because you're off duty. So let's say this, if you went into your place of business on the weekend or, on a time when you're not actually scheduled to go and you had relations with someone, you'd still get in trouble, right? Because it was on the job or on the premises, not on the it's not on the clock, but it's still technically on the job because of the location, in my opinion. So I think that that is being kind of disingenuous. Anyways, despite not having identified Mr. Heel as a subject of the investigation, Deputy Chief Brian J. Holmes recommended that Chief McNamara send a copy of the transcript of Mr. Heel's recorded interviews to Chief David Del Papa of the Abington Police Department. Upon information and belief, SPD sent copies of the transcripts of Mr. Heel's recorded interviews to Chief Del Papa and the ADP. At all times relevant, Stoughton PD, Stoughton, the town of Stoughton, the SPD, and the MSP knew and were aware that Mr. Heel was not the target of the investigation. So the town of Stoughton, Stoughton Police, and the Massachusetts State Police all knew Mr. Heel was not a target. At all times relevant, well, according to his lawyer, at all times relevant, Mr. Heel was a fact witness who was interviewed by SPD's IA investigation led by Deputy Chief Brian Holmes. Deputy Chief Holmes did not recommend that Mr. Heel be put on administrative, sorry, Deputy Chief Holmes did not recommend that Mr. Heel be put on administrative leave as a result of Mr. Heel being a fact witness in the IA investigation. Even after the IA investigation was complete, Deputy Chief Holmes did not recommend Mr. Heel be disciplined or terminated for his employment by the town of Abington and the ADP. So if he had been found in some misconduct, they probably would have said he's not worthy of being a cop. SPD found that, well, maybe, because as we do know in the medical profession and in law enforcement, when someone conducts misconduct on the job, oftentimes it goes underreported and these individuals can just kind of skip town and go wreak havoc on another town. And it happens all the time because there isn't some kind of reporting system that's, well, there is for police, but a lot of time the crimes or the incidents get kind of pushed under the rug and it's not really talked about. And then, therefore, these individuals, Robert Devine, William Farwell, Matthew Farwell, are all out and about, not sitting in jail, and potentially wreaking havoc on other people. So, ugh, I don't like to think about that, but it's true. All right, so The SPD found that Mr. Heel did not meet or know Ms. Birchmore until she was over the age of consent. SPD did not make any findings that Mr. Heel participated in any act, conduct, or behavior and constituted grooming behavior that is construed as exploitive of Ms. Birch. At all times relevant, SPD knew that Mr. Heel had no interaction, involvement, supervision, or participation in the Stoughton Police Explorers Program either before, during, or after Ms. Birchmore's enrollment in said program. So he's never had anything to do with the Stoughton Police Explorers Program. He's like, I wash my hands of it. SPD did not make any findings that Mr. Heel had any communication or contact with Matthew Farwell regarding the allegations raised in the complaint before or after the complaint was filed or while the acts alleged occurred. SPD did not make any findings that Mr. Heel had any communication or contact with William Farwell or Robert Devine regarding the same. They just repeat themselves over and over again. During its IA investigation, SPD failed to uncover any conspiracy where Mr. Heel conspired with Matthew Farwell, William Farwell, and Robert Devine. And that's important to point out because of that conspiracy charge, because of the whole that count 10, which is the conspiracy charge, which I'm glad we read through because look at this. He wants nothing to do with that conspiracy. He's like, he's laid out. Matter of factly, I don't know these people. I don't talk to these people. I know who they are just because they're in the department, but I don't talk to them. I'm not friends with them. Count me out. I did not conspire to do anything with Sandra with them. And no, count me out. I am innocent, is basically what he's claiming here. He's like, I do not know these people. Despite the SPDIA investigation failing to implicate Mr. Heel in any wrongdoing or unlawful act with respect to Ms. Birchmore on September 23, 2022, Chief Donna McNamara expressly and impliedly implicated Mr. Heel in the circumstances and allegations that were substantiated as to the co-defendants Matthew Farwell, William Farwell, and Robert Devine. I will admit that she kind of lumped them in with those three. Kind of. And there's another unnamed individual that she also kind of calls out. She says another unnamed individual who was the military recruiter that William Farwell got Sandra in touch with to get into the military. She wanted to go to the army. And there's that. So he may have been inappropriate with her too. But we don't know his name and we don't know the details. So I don't know if more is ever going to come out on that, but I hope so. All right. Where were we? So Chief McNamara implied these things. Despite the SPDIA investigation failing to implicate Mr. Heel in any wrongdoing or unlawful act with respect to Ms. Birchmore on September 23rd, 2022, Chief McNamara referred to Mr. Heel as another individual employed as a police officer in another town. Despite the SPDIA investigation failing to implicate Mr. Heel in any wrongdoing or unlawful act with respect to Ms. Birchmore on or about September 23rd or thereafter, the town of Stoughton by and through the Stoughton Police Department and its employees caused the IA investigation report to be disseminated to the public. So after or right about that time of the press conference with Chief McNamara of Stoughton PD, they released the IA investigation, which we read through. Upon information and belief, SPD took efforts to redact and conceal personal identifying information set forth in the IA report. Notwithstanding the efforts to redact and conceal personal identifying information, SPD released the IA investigation report without having redacted Mr. Heel's identity and disclosed his identity to the public. At that time of the release of the IA report, neither Stoughton nor the SPD nor its public records officer notified Mr. Heel of the report's impending release, nor did any of these entities or individuals allow Mr. Heel to object to the release of the report, which contained private identifying information of a personal nature which related to his own identity and information protected from disclosure that was pertinent to the terms and conditions of his employment with the town of Stoughton. So, by putting his name in the report or not redacting it, they put him in jeopardy, I guess, is what they're saying. At all times, relevant personnel information related to Mr. Heal's job duties, performance, or incidents occurring during his employment with the town of Stoughton were private and not subject to disclosure to third parties, even after he ceased working for the town, and especially because he was an officer. Despite the fact that personnel matters other than dates of employment and salary and compensation information are private, SPD released information to third parties that invaded Mr. Heal's privacy, which in turn caused significant and severe consequences and damages. For example, on or about January 10th, 2023, Kirk Minihane of the Kirk Minihane Show and hosted and a was a part of Barstool Sports featured the oh and a part of the Barstool Sports featured the Sandra Birchmore case on the podcast titled The Case. So that is a good uh, podcast to listen to if you want to get the facts and get the info about everything. Minihan is a well-known on-air antagonist who previously worked in the Boston sports radio market. During the podcast, Minihan made broad sweeping, verifiably false, and defamatory statements about Mr. Heal. Minihan exaggerated the December 7th, 2022 letter from Deputy Chief Holmes to Chief David Del Papa by claiming Mr. Heal was a material witness and insinuating Holmes could not get into specifics, and that Del Papa asked if he should place Mr. Heal on administrative leave. At all relevant times, Mr. Heal was not on administrative leave from the Abington Police Department. Minihane went on to say, by the way, says he's friendly with the Farwells. And he got into some stuff with Sandra, and he knew Sandra since 2015, and she was always around the Stoughton Police Department, and that Mr. Heal traded a cat in exchange for oral, you know what, with Sandra Birchmore. We know that's just a fact, and that's what happened. That's why they did the DNA test on the couch. Possible. SPD-IA investigation did not conclude that Mr. Heal was friendly with the Farwells. In this document, his lawyer is affirming he does not know them and he is not friends with them. And it is expressly related that Mr. Heal and the Farwells had no relationship whatsoever outside of work. The SPD-IA investigation showed definitively that Mr. Heal did not start employment with Stoughton until March 6, 2016. The SPD-IA investigation failed to disclose any evidence, nor did anyone involved with the investigation conclude that Mr. Heal traded a cat for oral with Sandra Birchmore, nor is that just a fact or what happened, nor is that why they did the DNA test on the couch. Well, why did they do the DNA test on the couch then? I mean, might not have been because he traded a cat for that, but he admitted to that happening. And I wonder if there was communications in their phone about it, because otherwise, why would he admit it? You know, if he wanted to save himself, I'm just saying, like he probably wouldn't admit it. Or if he did just come out and admit it, then he is being a good guy and just telling the truth, I guess. I don't know. I don't know. I still think he took advantage of her in some ways, even though she was a consenting adult. All right, so the SPD-IA investigation revealed that it was unclear if the couch in question was in the Stoughton Animal Shelter on the date when Sandra Birchmore is alleged to have engaged in consensual oral with Mr. Heal. The SPD investigation, IA investigation, and forensic investigation and analysis of the couch produced no physical evidence corroborative of any of Minihane's specious or false claims. Had Stoughton and SPD not released a partially unredacted IA investigation report identifying Mr. Heel, neither Minihane nor his fatuous and ill-advised acolytes would have targeted Mr. Heel. So he's saying he's having some distressing times because of this radio guy, Minihane. What is his name? Kirk. Kirk Minihane show. I don't even know if I'm saying that right, but he's from Barstool Sports, which I am familiar with Barstool Sports. But anyways, they do like pop culture and true crime stuff. So yeah, I mean, just bizarre. This whole thing's bizarre with everything. All right, so they're just saying, Josh didn't do anything wrong, and the one encounter that they had was consensual. Let's move on from it and let's not, dwell on it. Also, my guy didn't have anything to do with these grooming and no conspiracy, nothing, not a walk away. They're trying to really distance themselves from the crimes, which I don't, if he is innocent of all these things, I don't blame him for being a little upset. This goes on to talk about the press release, damages that he's suffered. I'm not going to read all of it because I'm going to give you guys a link and you can see below. It goes on for quite a while, as you can see. Um, they talk about, how his identity was leaked because of that. They're going count by count and going to tell you what's wrong with each of the counts. So I'm going and why Mr. Heel is not guilty of any of those crimes. So yeah, I told you it's long, but I will give you the link below so you can go back and look at all that if you want to. So the next response is the town of Stoughton, and they are, a lot of it is they don't have information, or some stuff admitted, some stuff, we only admit to this much. Like Stoughton admits the allegations in corresponding paragraph of the complaint to the extent that the decedent participated in the Explorers program from around 2010 to 2016 and that she met defendants in connection with her participation in the program. Stoughton denies the remaining allegations of the corresponding paragraph. So we admit she did go there from that time to that time and she met those people, but we deny that they had any kind of improper relationship with her. So that's where the town of Stoughton is standing. Everything denied, denied, deny. This one is the answer from William Farwell. We're not going to read through all of this either. A lot of it is denied or is without knowledge. That's different than the insufficient knowledge is without knowledge. Lots of denials. And they like to reaffirm their amendments. Like William Farwell reserves the right to supplement his defenses following discovery in this matter. So they're like affirming their rights here is what this is. For future, to protect it from the future. All right. Let's see. What do we got? Next is a joint motion for court order to inspect and copy records of the Office of the Chief Medical Examiner. So this is important because this was back in, when are we here now? Looks like it says 2/21/23, but then it also says 2/14/24. So I'm not really sure. Let me see if there's a date down here. Um, I don't see a date. Certificate of service. I don't know. There's no date on here. Not seeing a date. But anyway, so this is all of these people came together and stipulated, yes, we want to release those records because in doing so, we can learn what happened to Sandra. So they want to release the medical examiner's autopsy records. Um, sorry, we've got mail probably being delivered. So they want the medical order or the medical examiner's autopsy records released. So that was granted. Now we're moving on to order for inspection and copies of records. I guess that's the same thing. Um, Here's the certificate of death, which is really difficult to read, but it says here the manner of death is pending investigation. And over here it says cause of death is pending. So it is an open investigation currently. All right, so now defendant William Farwell joins the joint request. They all want to release the autopsy. Where are we at now? So 3/26/2024. Defendant Robert Devine's motion to release unredacted internal affairs report. So he wants an unredacted copy. All right, then. And a memorandum to support it. Then we have a bunch of these, which is the proposed protection order and clawback provision regarding exhibits, internal affairs. So basically, they want a protective order on certain things, certain exhibits and whatnots. So that's what that's about. I'm sure it was granted. This next one, partially assented to motion to compel the production of documents from Attorney General's office. So this is where we currently are, I believe. So this was 5/22/2024. So May 22nd of this year, multiple people, the defendants, multiple people on here are asking the Attorney General's office. So, okay, so the Stoughton PD did their own internal affairs investigation. We got that back. Now, the state attorney, so the Massachusetts Attorney's Office, is doing their own investigation, and they are asking for these documents. These documents will help in preparing for trial. These documents will help in understanding more about the case. So they're arguing in our next episode. That's what we're going to be watching is a hearing about obtaining this discovery from the AG's office. And then that's the memorandum in support of, just trying to go through these pretty quickly because there's nothing really of substance that I think we would find all that interesting right now. It's hereby ordered that the Attorney General's office shall produce the records that they want. This is for William Farwell. Um, Whether they did or not, they might have fought that. I'm not sure. We got some emails from the Office of the Attorney General. Enclosed in connection with the above referenced matter, please find a copy of a deposition subpoena to the keeper of the records of the Office of the Attorney General. Please be advised that you have 10 days from the date of this letter to file objections to the subpoena. So, Darlene Smith versus William Farwell. So it's a subpoena for a deposition. Or a copy of the deposition. Sorry, it says a copy of the deposition enclosed. Oh, a copy of the deposition subpoena enclosed. Sorry. I really need to like focus. It's not that I'm not focusing. It's like I read the words, I hear them. All right. So a copy of a deposition subpoena. So he is being subpoenaed to a deposition. So that's what this is about. William Farwell is. Up next, keeper of the records. This is same. You are hereby commanded in the name of the Commonwealth of Massachusetts, in accordance with the provisions of Rule 45, blah, 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 blah. You are further required to bring with you the deposition those items in attachment A attached to the deposition. So this is basically, it is, um, but who's it addressed to? That's what I'm wondering. I don't know if it's just William Farwell. This is probably just a copy of the letter that William Farwell received, but I don't know if it went to everybody. That's what I was looking for. Then we got another letter that says notice of taking deposition. So April 22nd, 2024 at 10 a.m. The Office of the Attorney General, and you can get certified copies. Okay. That's what they're supposed to bring. What else? Affidavit of business records and or report. Um, okay. This is just something from the keeper of records, whatever that is. All right, Second Amendment, amended complaint and demand for the jury trial. So we're amending this complaint one more time and submitting it again. Very long. Same thing. I write in response to a third party subpoena duces tecum. Oh, so this is a response dated March 18th. All documents and records of any kind in your possession, custody, or control pertaining to the welfare check that took place on February 4th involving the decedent Sandra Marie Birchmore. Oh, I like her middle name. And the Stoughton Police Department and the allegations thereafter. So this is a preservation order that was sent to the defendants, I'm sure. I'm not going to read it all, but um, yeah. All right. That's boring legalese. Another protective order. So that's, I mean, we're getting to the nitty-gritty here. I don't want to bore you, but partially assented motion to compel the discovery. So again, they're asking, it's another motion to compel the discovery from the AG's office and the memorandum of law to support it. And what else? We got order to produce documents. So it is hereby ordered that the Attorney General's office shall produce the records requested by the defendant William Farwell in his March 18th subpoena duces tecum to Defense Counsel Attorney David M. Bay from Boyle and Shaughnessy Law within 20 days of the date of this order. Mm, this is just saying you have 10 days to object, blah, blah, blah. The more people are getting a subpoena. Okay. I feel like we were reading the same thing over and over again. Affidavit to business records. We did see that. Okay. I think this was in here twice. I don't know why. All right. Now you guys get the point. The rest of it's like protective orders and stuff. So, um, and pretty much the same things that we've already looked at. So, I just wanted to bring you current and up to date. Let's get all the way to the end here. What's the last thing that we've got? I think same thing we've been looking at. What is this? This is the AG. Oh, crap. We got to read this. Okay. So now this is the AG's third party opposition to defendant's motion to compel. So they don't want to turn this over. And that's why in the hearing that we have that we're going to listen to, it's arguing this particular content. So now comes non-party office of the Attorney General hereinafter AGO, and hereby opposes defendant William Farwell's hereinafter Farwell motion to compel the Attorney General office to produce documents. In addition to its opposition, the AGO requests that this court vacate Farwell's March 18th keeper of records subpoena ducis tecum that was served on non-party AGO in its entirety. As grounds, the AGO states 1. The documents identified in the subpoena are exempt from disclosure because they are part of an ongoing law enforcement investigation, and their disclosure would jeopardize the investigation. Keep that in mind because that is often their excuse as to why they don't want to turn stuff over. Um, and not just the AGO's office, but a lot of times that's an excuse is, oh, it's an ongoing investigation. You can't have it, even with like FOIA requests and things like that. Number two, to the extent that the subpoena seeks communications between assistant attorney generals and between assistant attorney generals and other law enforcement agency prosecutors regarding the open AGO investigation, those communications are protected from disclosure under the attorney client privilege and common interest doctrine. And three, the subpoena is unreasonable because it seeks documents either already in Farwell's possession or that originated from separate and distinct law enforcement agencies. The subpoena also causes an undue burden on non party AGO because it is vague and overboard and requires the AGO to interpret the allegations in the second amended complaint to certify whether it has produced or withheld all responsive records. Relevant factual and procedural history. On December 29th, 2022, plaintiff Darlene Smith, as the personal representative of the estate of Sandra Birchmore, filed a complaint in the instant matter. On February 2nd, 2023, plaintiff filed the second amended complaint alleging wrongful negligence, negligent infliction of emotional distress, civil conspiracy, and 42 U.S.C. 1983 arising out of the named defendants' relationships with Sandra Birchmore and the circumstances involving her homicide after she was found to be deceased by the Canton Police Department during a welfare check on February 4th, 2021. And this is almost a year prior to the uh, incident where Officer John O'Keefe was found on Brian Albert's lawn. And that was January 29th, 2022. So we are like right at a year, right around a year apart. All right, so since that time, the parties have engaged in motion practice and the court has endorsed a protective order and clawback provision regarding certain exhibits from the Stoughton Police Department's internal investigations affairs. On March 18th, 2024, Farwell served non-party office of the Attorney General with a keeper of the records deposition subpoena ducis tecum seeking all documents and records of any kind in your possession, custody, or control pertaining to the welfare check that took place on February 4th, 2021, involving the decedent Sandra Marie Birchmore and the Stoughton Police Department and the allegations, therefore, with reference to the allegations enumerated in the Second Amendment complaint. Such documents and records to include, but not to be limited to, any and all logs, run sheets, call recordings, and other documents and materials, all photographs taken, generated, or otherwise obtained, all reports, citations, notes, memorandum, correspondence, email, or other paperwork and or documents generated or otherwise obtained during all evidence taken from the scene, all statements taken from any person associated with the incident, and all 911 calls, transcripts, and or tapes generated as a result or in connection of the incident. I just want to say thank you to all you legal people who make these sentences run on and on and on. It's hard to take breaths when you're reading through them. Very difficult. All right. So on April 19th, 2024, pursuant to Mass R Civil Procedures 45D1, The AGO served an objection to Farwell's Keeper of Records deposition subpoena. The AGO objected to Farwell's subpoena on the grounds that the documents sought were privileged under the investigatory privilege, that the attorney-client privilege, and the common interest privilege and other statutory exemptions. So they're saying it's covered under the privilege, under some kind of privilege. Or on or about June 3rd, 2024, Farwell filed a partially assented to motion to compel the production of documents from Attorney General's office. On June 5th, 2024, non-party AGO filed a motion for an enlargement of time to respond to Farwell's partiality assented to motion to compel. The records sought by Farwell that are in the possession of the AGO are part of an ongoing criminal investigation by the AGO, disclosure of which would jeopardize the integrity of the investigation and would not be be in the public interest. This is like the standard boilerplate answer. Disclosure would jeopardize the integrity of the investigation and wouldn't be in the public interest. This is always the standard boilerplate answer that you give when you don't want to answer a question coming from law enforcement or a prosecutor's office or something. Moreover, Farwell's subpoena specifically seeks reports, witness statements, calls, evidence logs, and videos pertaining to the February 4th, 2021 welfare check on Sandra Birchmore, which originated from the Canton and Massachusetts State Police Departments, not the AGO. To the extent the subpoena seeks documents that are contained within the Stoughton Police Department internal affairs investigation, those records are likely in Farwell's possession pursuant to the orders. So she's saying that they already have the information most likely because their information came from the Massachusetts State Police or Canton Police or Stoughton Police. They're not the originators of the information, of the evidence. So likely Farwell already has what the AGO's office has. It's just that they don't realize it. But again, I also think it's kind of a cop out. Like we don't want to give them our work product type stuff. All right, so argument. Farwell's motion to compel should be denied and the subpoena should be vacated in its entirety because the documents sought are part of an ongoing AGO investigation. Farwell's motion to compel should be denied and his March 18th Keeper of Records subpoena to non-party AGO should be vacated in its entirety because it seeks documents that are part of an active and ongoing investigation into the circumstances surrounding the homicide of Sandra Birchmore, and the conduct of former members of the Stoughton Police Department, along with their relationships with Sandra Birchmore, and as such are exempt from disclosure. Although Massachusetts courts have recognized that the investigatory privilege is absolute, it is qualified in this context by the Massachusetts Public Law Record, General Laws, Chapter 6610, which provides that investigatory materials compiled outside of the public view by law enforcement or other investigatory officials are public records provided that disclosure of such materials would not so prejudice the possibility of effective law enforcement that such disclosure would not be in the public interest. Basically saying the same thing that they keep reiterating. Under General Law C-4726F, any investigatory materials necessarily compiled out of the public view by law enforcement or other investigatory officials are exempt from the definition of public records if disclosing such materials would probably so prejudice the possibility of effective law enforcement that such disclosure would not be in the public interest. So if basically they're saying if we come out with information on this, it would be detrimental to maybe the capture of the right perpetrators. I don't know, but it doesn't seem like they're doing a whole lot to to right this wrong so far that we can tell because they're still investigating, I guess. and we don't know anything yet. The investigatory exemption is aimed at the avoidance of premature disclosure of the Commonwealth's case prior to trial, the prevention of the disclosure of confidential investigative techniques, procedures, or sources of information, the encouragement of individual citizens to come forward and speak freely with police concerning matters under investigation, and the creation of an initiative that police officers might be completely candid in recording their observations, hypotheses, and interim conclusion. Alrighty. The exemption applies where disclosure of the records would detract from effective law enforcement to such a degree as to operate in derogation and not in support of the public interest. Okay, but how? Like, what happens? They haven't explained how coming forward with these documents would be detrimental to their serving justice or law enforcement being um, being had. I don't know. Effective law enforcement. All right. So first, the only records AGO has in its possession that pertain to the February 4th, 2021 welfare check of Sandra Birchmore are one, a Canton Police incident report and supplemental narratives regarding the February 4th, 2021. Two, a number of Massachusetts State Police records regarding the February 4th, 2021 welfare check and unattended homicide investigation of Sandra Birchmore. And three, Stoughton Internal Affairs investigation involving the named defendants and the corresponding exhibits and digital evidence. Four, third-party records obtained by a Massachusetts State Police assigned to the Norfolk County District Attorney's Office pursuant to a warrant. John Fanning, Sergeant John Fanning, or Lieutenant Fanning, who was also on the text communication chain with Michael Proctor in the Karen Reed case. While Proctor was saying a whole bunch of dehumanizing things about Karen, Lieutenant Fanning, a superior of Michael Proctor, was on those text chains, along with Buchanan was on there and other supervisors of his, but it just goes to show it is the work environment. That's the culture. If he was feeling so carefree to say those things when he had supervisors, people who were at the rank of lieutenant on his text chain, if he was able to say those things and not feel like he was going to get any consequences, what does that say about the culture? Honestly, I mean, it's just so gross. So this would be Fanning, probably the Massachusetts State Police third party assigned to the Norfolk District Attorney's Office. All right, so of these records, Farwell is likely already in possession of the Stoughton Police Internal Affairs investigation. So basically, they're saying we have pretty much the same things that he has, and we don't have anything else that we can turn over. With respect to the Canton or anything else that is not privileged or protected. With respect to the Canton and Massachusetts State Police reports, these records consist of the observations and investigative activity of Massachusetts State Police personnel, witness statements obtained by Massachusetts State Police investigators, and digital forensic evidence. With respect to third-party records obtained by warrant, the specific contents of those records are confidential because they are a part of the AGO's ongoing investigation into the conduct of certain former Stoughton police officers and their relationships with Sandra Birchmore. So this is the first time they're really saying why it is pertinent or why it might be confidential, because it is involving the investigation of the officers involved. Disclosure of the Canton, Massachusetts State Police records, which contain witness statements and the investigative activity of the Massachusetts State Police investigators, could potentially undermine the AGO's ongoing investigation to the parties in the instant case. In the instant case, would be particularly detrimental to the AGO's investigation because it involves the named defendants. The release of witness statements and investigative activity could taint future witness interviews, allow witnesses and/or suspects to shape their responses. I mean, this makes sense here. And she didn't really reference this on the hearing that we're going to talk about, but that's a good point. The release of witness statements and investigative activity could taint future witness interviews, allow witnesses and other suspects to shape their responses to investigators' questions, and discourage additional witnesses from sharing information with investigators. So that those are the points that I think she really needs to hone in on um, in her arguments here. Likewise, sharing the digital forensic evidence and documents obtained through the Massachusetts State Police warrant with the subjects of the AGO investigation as part of the civil lawsuit would undoubtedly jeopardize the integrity of the ongoing investigation. Farwell mistakenly argues that he is entitled to the records because there is no criminal case pending against Farwell or any person arising out of the Birchmore homicide, which occurred more than 3 years ago. The fact that 3 years have passed since Ms. Birchmore's homicide is not dispositive in determining whether the investigatory exemption applies. So time doesn't matter. Exemption applied in homicide investigation that occurred 5 years ago and was still ongoing and active. That's what they're referencing. Indeed, courts have applied the investigatory exemption to inactive and closed investigations. Here, the AGO has provided the requisite insight as to the confidential nature of the records in its possession by providing an affidavit that lists the records in its possession, a general description of their contents, and the agencies from which they originated. So we're trying to be here in good faith. So because I can't give you everything, how about I give you some of it? Where were we? Thus, the AGO has established by a preponderance of the evidence that the police reports, digital forensic evidence, and records obtained by warrant are exempt from disclosure. In addition to police reports and any and all documents pertaining to the welfare check of Sandra Birchmore on February 4th, 2021, Farwell's subpoena also seeks 911 calls, cruiser and body worn camera videos, run sheets, logs, call recordings, photographs, and evidence pertaining to the welfare check on Sandra Birchmore, which are not in the possession of the AGO. Like, why are you asking the AGO for these things? They should be, Stoughton should have them, or Canton should have them. Whoever was investigating should have all that stuff. So, where is it if it's non existent? That's a problem. To the extent that they exist, those records are likely in the possession of the Canton and/or Massachusetts State Police Departments where they would have originated and where Farwell's Keeper of Records subpoena is more appropriately directed. Accordingly, the court should deny Farwell's motion to compel and vacate the March 18th, 2024 Keeper of Records subpoena to non-party AGO because the police reports, digital forensic evidence, and records obtained by warrant are exempt from disclosure as it would probably so prejudice the possibility of effective law enforcement that disclosure would not be in the public interest. Farwell's motion to compel should be denied and his subpoena should be vacated to the extent it seeks attorney client communications and communications that fall under the common interest doctrine. Farwell's motion to compel should be denied and his subpoena should be vacated to the extent that the subpoena demands production of attorney client privilege communications. Farwell's subpoena demands any and all documents or records of any kind in your possession, custody, or control pertaining to the welfare check that took place involving the decedent and the Stoughton Police Department and the allegations thereafter in reference to plaintiff's second amended complaint. To the extent Farwell's subpoena seeks communications between Assistant Attorney Generals that relate to the February 4th, 2021 welfare check on Sandra Birchmore, such communications are protected from disclosure by the attorney-client privilege. To the extent that the subpoena seeks communications between Assistant Attorney Generals and external prosecutors regarding the circumstances surrounding the homicide of Sandra Birchmore, and the conduct of former Stoughton police officers, including their relationships with Ms. Birchmore, such communications are privileged under the common interest doctrine. Broadly stated, the common interest doctrine extends the attorney client privilege to any privileged communication shared with another represented party's counsel in a confidential manner for the purpose of furthering a common legal interest, I would say. I think there's some typos in there. But so basically, sorry, I got text messages coming in. All right, so accordingly, Farwell's motion to compel should be denied and his subpoena should be vacated to the. Did I read all that? I don't know where I got lost. My mom's having surgery today, so I'm kind of like in two places at once. All right, so broadly stated, common interest doctrine extends the attorney-client privilege to any privileged communication shared with another represented party's counsel in a confidential manner for the purpose of furthering a common legal interest. So one attorney can give it to another attorney but like without, sometimes they can even keep that information from their clients. So it's like you can get the discovery, but you can't share it with your client. And that has happened in even recent things with like Aiden Carney and stuff on regarding his case for witness intimidation. They don't want him to be spreading it, through his media, through his platform. Anyways, accordingly, Farwell's motion to compel should be denied and his subpoena should be vacated to the extent it seeks attorney-client privileged communications and communications protected by the common interest doctrine. Farwell's motion to compel should be denied and his subpoena should be vacated because it is unreasonable and creates an undue burden on non-party AGO. So they're saying it's causing me more hassle. Farwell's motion to compel should be denied and his subpoena should be vacated because it is unreasonable and creates an undue burden on non-party AGO. Rule 45B of the Massachusetts Rules of Civil Procedure states that a court may quash or modify if it is unreasonable or oppressive. When determining whether a Rule 45D subpoena ducis tecum results in an undue burden, factors to consider include the relevance of the document sought, the necessity of the document sought, and the breadth of the requested, and the expense and inconvenience. Concern for the unwanted burden thrust upon non-parties subject to subpoena is a factor entitled to special weight in evaluating the balance of competing needs. Farwell's keeper of records subpoena is unreasonable because it demands the AGO to produce documents that are either already in Farwell's possession or originated from two separate and distinct law enforcement agencies. To the extent Farwell's subpoena for any and all documents pertaining to the February 4th welfare check commands the production of the Stoughton Police Internal Affairs investigation and corresponding exhibits he likely already has in his possession. Farwell also subpoenas from the AGO records that were created and or maintained and are maintained by the law enforcement agencies, namely any and all logs, run sheets, all recordings, photographs taken, video from cruiser cameras and or body cameras, all reports, citations, notes, memorandum, correspondence, email, or other paperwork and or documents, all evidence taken from the scene, all witness statements taken from any person associated with the incident and all 911 calls, transcripts and or tapes in connection with the discovery of the decedent Sandra Birchmore during a wellness check on February 4th, 2021. God, these sentences are so long. The AGO, it's like one paragraph long. Um, The, the AGO was not involved in the February 4th, 2021 welfare check on Sandra Birchmore. Rather, the welfare check was conducted by Canton police officers who then notified Mass State Police when they discovered that Ms. Birchmore was deceased because that's who takes over for homicide investigations is the state police. Indeed, the AGO is not in possession of most of the specific records listed in Farwell's subpoena. A party or attorney reasonable for issuing and serving a subpoena must take reasonable steps to avoid imposing undue expense or burden. Farwell failed to take such reasonable steps to avoid creating an undue burden on a non party when it issued a subpoena to the AGO for records that originated and are maintained by other law enforcement agencies. Finally, Farwell's is overbroad and vague, and as such causes an undue burden on the AGO, particularly in that it seeks any and all documents or records of any kind in your possession, custody, or control pertaining to the welfare check that took place. I could read all that over and over again. In order for the AGO to certify that all documents responsive to Farwell's subpoena had been produced or withheld, a review and interpretation of the 81 paragraph second amended complaint would be required. For example, the subpoena requires the AGO to review the allegations in paragraph 35 of the second amended complaint, which states an employer's knowledge of past acts of impropriety, violence, or disorder on the part of the employee applicant is generally sufficient to forewarn the employer that the employee may commit such an assault during their employment and determine whether it had any responsive documents. In that same vein, it also requires the review and interpretation of paragraph 69, which rates or it states the R word and SA by state actors and officials can violate the Constitution and serve as the basis of a 1983 claim. So just that alone can uh, they can make a claim for um, for what for these officers that they are violating Sandra's constitution or constitutional rights and determine whether the AGO had any responsive records. Such an extensive exercise of interpretation and speculation by a non party based on the breadth and ambiguity of the language in the subpoena causes an undue burden on a non party. Accordingly, Farwell's motion to compel should be denied, and his March 18, 2024 Keeper of Records subpoena to non party AGO should be vacated in its entirety. Wherefore, and for the foregoing reasons, non party Office of the Attorney General respectfully request that this court deny defendant William Farwell's motion to compel the production of documents by Attorney General's office and vacate defendant Farwell's keeper of records subpoena in its entirety. Whew, that was a lot of reading. All right, so we're going to stop here. Sorry that this went so long. I didn't really mean it to be 2 hours, but I thought what we did read through was pretty interesting and we learned some new things here. So I enjoyed reading through it, even if it was a little bit longer for you guys. Next up, we will watch the July 12th hearing, which is specifically on the AGO's arguments and not turning over certain uh, turning over their discovery because it could be, because it's under investigation and it could, be detrimental to their case if they make any of their information public. So we'll listen to that, and then after that, we will be almost caught up. The next thing will be um, the hearings for Robert Devine and William Farwell. We know Matthew Farwell decertified. He's already out of there. He cannot be a cop ever again. When it comes to Matthew Farwell and Robert Devine, they're probably I think Matt Farwell is considered not certified, which means he's on administrative leave. So I would think Robert Devine is too, but I'm not exactly sure. I don't know how, it could be different for everyone. So that's kind of where we're at. I look forward to seeing you guys next time. Now that the Karen Reed trial's over, and some of the craziness from the Karen Reed trial seems to have died down a little bit, I'm able to push these out faster. So hopefully we'll be all caught up very soon. So thank you guys so much for watching with me. I apologize for what happened last night. I don't know, my OBS, which is what I use to record, just all of a sudden decided, hey, I don't remember your microphone anymore, even though you've had me connected to your microphone forever. So I don't know. Recorded multiple videos where my microphone wasn't working. So hopefully everything is all fixed, and I will see you guys in the next one. Thank you so much for your patience. I'll see you guys in the next one. Take care. Bye now.